The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you and good morning. The next case is State versus Hammer, and we'll hear from the appellant.
May it please the court, Chief Justice Newby and Associate Justices. My name is Mike Spivey. I represent the appellant Demond Hamer in this matter. I'd like to reserve 5 minutes of my time for rebuttal. I want to talk first briefly about the historical context of jury trials in North Carolina, because that's the context in which this case has to be decided. I'll turn to the 2014 amendment of the Constitution permitting waiver in jury trials, because I believe that the answer and resolution of this case lies in the language of the Constitution itself. To talk about the historical context, let me first say that I've been practicing law in the trial courts of North Carolina for more years than I want to think about. And I've been in and out of courtrooms that I can count. And I realized in preparing for this case that one of the things that I never really paid that much conscious attention to was the jury box in every courtroom I've been in. And that is so because the right and requirement of a jury trial in North Carolina has been so fundamental that I've had no real cause to think about it. It just is always there, always has been there. And one of the things that I read about or ran across in reading and researching to address this issue with the court today is a historical event that really brought home to me how important this right is to the people of this state. Last month in Pender County, there was a ceremony at Moores Creek Bridge at the National Park there. And the ceremony was to commemorate the 245th anniversary of the Battle of Moores Creek Bridge, which was, interestingly enough, the first decisive Patriot victory of the Revolutionary War. On the occasion of the ceremony that was conducted last month at the bridge, it was done virtually, and the park superintendent appeared at the foot of the Moores Creek Bridge. And he noted that because of the pandemic, the ceremony had to be held virtually this year. And he commented that a benefit of doing it virtually was that we could all sit in the comfort of our homes, on our couch, in our favorite chair, and enjoy the ceremony from there. And what struck me about that was that today we are appearing virtually to talk about that right. And we have the privilege of doing that because 245 years ago, the founders of this state and this nation literally died for us to have that right. Now, in the what is now more than 200 years of this court's existence, this court has been steadfast and resolute in never permitting any encroachment whatsoever upon that right. I think when people in general think about the right to a jury trial, they think in terms of a defendant's right, that it's the defendant's right to a jury trial. And certainly, surely, that is true. But that's not the only purpose. The jury trial is a part of a command in the original creation of our government by Constitution that said it places a limit and a restraint upon the power of government. It is the people saying to their government that they created that no person in North Carolina shall be convicted of any crime, except by the unanimous verdict of a jury in open court. This court has always held that that is an absolute right, that it means that there's going to be a unanimous verdict by a jury of 12 if any valid conviction is going to occur in any criminal case, and any violation of that right is a structural error that nullifies the trial. Now, of course, that changed in 2014, and that is what has landed us here today. In 2014, the people of North Carolina decided that it would be wise to amend their constitution to permit waiver of jury trial in certain very limited circumstances on certain conditions. They did not work a radical alteration of the Constitution or the established law that has developed under that Constitution. They simply inserted into the existing language of our Constitution an exception. And in doing that, they used plain, clear, ordinary English words that anybody can understand the meaning of. What they said was that a defendant may waive the right to a jury trial with the consent of the trial judge, subject to procedures prescribed by the General Assembly. And of course, it's that last phrase that is the one that has brought us here today. Because what has happened since these cases have begun to come into court and waivers have occurred is that one of the concerns that people were reluctant to, or people had that made them reluctant to want to have jury waiver in North Carolina was a concern that eventually it was going to lead to the erosion or diminishment of the right to jury trial itself. And I think to some extent that's what we are already seeing, because we're not seeing cases where the Constitution has been followed before a waiver occurs. Instead, we're seeing cases where the Constitution has not been followed, and the courts are trying to deal with those cases. And in doing so, they are, I would say to you, in effect, rewriting the people's Constitution. What the Court of Appeals said in this case was not that the procedure prescribed by the legislature pursuant to the Constitution was followed, but that it was not followed, but it didn't matter unless the defendant could show he was prejudiced, which is, of course, an almost impossible task. You know, how does one show that one of 12 jurors might have had a reasonable doubt based on the facts of the case, as opposed to the opinion of a single judge? You're seeing cases like this one here, where not only was the statutory procedure not followed, but nobody directly, the court at least, did not directly address the defendant in the case and talk to him about jury waiver at all until after the state had already presented evidence. So the question becomes one of how far are we going to stray from the language of the Constitution? Because the Constitution didn't say, the people of North Carolina did not say, that you can waive jury trial subject to some of the procedures enacted by the legislature. They didn't say that you could waive jury trial to whatever procedures the court chose to approve that were enacted by the legislature. The language is clear. There's nothing confusing about it. It is right in the Constitution. It says a waiver must occur subject to the procedures enacted by the General Assembly. Now,
Counsel, Counsel, before you get too far away from having said that word prejudice, that's one thing I wanted to explore with you because I made a special note of it. Your brief focused upon the issue of the defendant's ability to make a knowing and voluntary waiver. And the bulk of your brief addressed that, but you have very little response in your brief to what the Court of Appeals majority said about, quote, defendant is not entitled to relief because he cannot meet his burden of demonstrating prejudice, unquote. You mentioned prejudice today just a bit ago, but you don't say a whole lot in your brief about it. Give us the substance, if you will, as to why you feel as though there was prejudice against your client in this case?
Justice Morgan, let me first say I don't believe he has to show prejudice, because I believe that absent a constitutionally valid waiver of jury trial, prejudice it's structural error. He doesn't have to show anything more. If you are asking me to address, was he prejudiced in this case, particularly ignoring the other issues in the case, then I would say yes, he is. You cannot tell from this record what Mr. Hamer knew and understood about the right to jury trial. He represented himself in district court without a lawyer. He appealed to Superior Court. We don't know and cannot know how it came about that his lawyer waived the right to jury trial. Whether there were discussions between him and Mr. Hamer, we don't know. There's nothing on the record that shows us. We don't know what Mr. Hamer understood as far as what that right entails. Did he understand that it means he gets to participate in selection of the people that will decide his case? Does he understand that that's going to mean 12 people who have to be unanimous in order for him to be convicted? The record doesn't tell us that, because those issues were never addressed. When the trial court realized that it had erred by not talking to Mr. Hamer and personally addressing him before trial and tried to correct the error, the court asked him, did he agree with what had already happened? The court explained to him what the possible penalties were for the offense that he was being tried, but the court didn't explain to him what the right to a jury trial entails at all.
So are you saying that?
So we can.
Are you saying that there's per se prejudice as a result of this? Then that on its face it is inherently prejudicial?
Yes.
And there need be no showing by the defendant in a case like this that there was prejudice, because the prejudice is inherent in the fact that he was not given the knowing and voluntary waiver opportunity prior to the initiation of the trial.
That's correct, Your Honor. If the waiver doesn't occur in a constitutionally valid manner, then there is no constitutionally constituted trier of fact. There is no legitimate or a verdict that can be upheld.
Thank you.
Yes, Your Honor.
Just to follow up, what, in your view, should the trial court have done at the point at which it realized that the statute required more and that they had not engaged in a direct colloquy with the defendant?
I think that the trial court's only correct option at that point would have been to declare a mistrial, which would have left the court open at that point to do one of two things: either simply continue the case, having declared a mistrial, or in the alternative, the parties might perhaps have agreed to simply start the trial over again. I don't know, but what I believe the judge could not do is simply go on with the trial at that point.
And presumably starting the trial over again after he had asked all the necessary questions under the statute.
I'm sorry, I didn't quite understand your question.
I'm sorry. So I was just to just kind of fully flesh out this question of what the trial court should have done. I assume when you say the trial court could have started the trial over again, that would have been after it engaged in the necessary statutorily required procedures.
Yes, that's correct. It would be a complete start from the very beginning, follow the correct statutory procedure. The problem here would have been in doing that and immediately starting a retrial is that because you haven't followed the statutory procedure up to that point, I don't believe you can then start over in terms of let's let the defendant waive right now. Let's not let him have the waiver or revocation of waiver period required by the statute. You start bringing all of those other factors into play. My position is that in light of the clear language of the Constitution, the legislative procedure for waiver has got to be strictly followed. You know,
and Mr. Spivey, that raises a question that I was planning on asking you, so let me do it here now. Are you arguing that any deviation whatsoever from the uh, requirements of the relevant statutory provisions by itself constitutes error per se, because those statutory provisions are incorporated by reference into the constitutional provision?
Yes, that is exactly what I'm saying, Your Honor.
All right. Now, in what way specifically was there a deviation here? Are you contending that there was a deviation as to notice?
Yes, there was no notice in the case. The only thing we know is it appears from the transcript that apparently the state's attorney and the defendant's attorney had talked with the trial judge and at least told the trial judge that they planned to have a bench trial.
So would it be fair to say that while the record does not reflect statutorily compliant notice in a narrow sense, the trial court, prosecutor, and the defendant, at least through his counsel, were aware that waiver of trial by jury was on the table?
Your Honor, if you're asking me, were the parties aware that they couldn't do a bench trial?
I guess my question really more goes to would you concede, if not, it's fine that you don't, but would you concede that at least the purpose of the notice provisions writ large, i.e. that everybody knew what the proposed approach was going to be, was accomplished here?
No, the purpose of the notice provision was not accomplished at all here.
Okay, why not?
Had notice been correctly given, then what would have happened is there would have been a date scheduled in court for there to be a hearing at which Mr. Hamer could have been personally addressed by the court, had the right explained to him, and decided whether he wanted to waive or not. And he then would have had a 10-day period to revoke if he got cold feet and changed his mind.
Okay. All right. Secondly, I mean, it is clear that you from your brief that you contend that the colloquy that the trial court had with the defendant after realizing, following the state's evidence, that there was non-compliance with at least part of the statute, your contention the colloquy is inadequate. What is a minimally adequate colloquy for purposes of 279A20-1 as you understand it?
Your Honor, I think a minimally adequate colloquy to ensure that you're having a knowing and voluntary waiver of the right is, number one, the court needs to explain to the defendant that the right to a jury trial encompasses the defendant's right to participate in selection of a jury of 12 people who must render a unanimous verdict to decide the case. I believe the court has got to make some inquiry to ensure that the defendant has not been promised anything or threatened or coerced in any way into giving up and waiving the right to a jury trial. And there were no questions about that at all in this case. And to me, those are the key issues that need to be addressed at a minimum by the trial court. I know that other states have gone all over the board on this issue, basically some of them saying you don't really have to do much of an inquiry at all, to others having a very elaborate inquiry. But at a minimum, the defendant has to know and understand what the right is that he's waiving, and it has to be a free, voluntary choice without any coercion, threats, or improper inducements.
Counsel, is it still prejudice if the trial court, even at the belated stage, afforded the defendant an opportunity to say that the defendant did not want to go forward with the trial, which it appears from the colloquy the defendant would have had an opportunity to do in terms of perhaps looking at the presentation of the state's case, seeing perhaps arguably how strong it may have been against him, or for whatever reason saying, you know, I don't think I want this after all, trial court. So as a result, I'm going to take you up on your belated colloquy offer not to have a bench trial and to go forward and want to have a jury trial after all. Was that available to the defendant here? And if it was, would that still constitute prejudice?
Your Honor, certainly the trial judge talked to the defendant briefly after the state had rested its case. But I don't believe anything could have been done at that point to salvage the situation for two reasons. One, just as a practical matter, turning to a defendant where his lawyers already waived jury trial and everybody else has agreed to that, and you wait till the state presents all his evidence, and he's got to look over at his lawyer who he's relying upon to defend his rights, and he's got to look up at the judge who may be sentencing him and say, no, I don't like what's going on here. I want it to stop. That puts a defendant in a very difficult, awkward position that he ought not be in. That's the practical side.
But would that not have corrected the prejudice? While you do say that perhaps that could create an awkward situation for the defendant, nonetheless, doesn't that cure the prejudicial aspect of this if he has a right to proceed at that point with a jury trial and reject what was at that point an erroneous constitution of a trial for him?
Your Honor, that does not correct the problem. And the reason it does not correct the problem is in the Constitution itself. That is not a procedure that the people of North Carolina authorized in the Constitution. The procedures enacted by the General Assembly are part of the Constitution. That's clear from the language of the Constitution. And the courts have no authority to go beyond what the people have declared the law is going to be on this issue. So, no, sir, you can't depart from what the Constitution requires, the procedures enacted pursuant to the Constitution, because otherwise you're departing from what the people of North Carolina have authorized in their Constitution. Let me just briefly add to that. There is a lot of different ways that the legislature could have approached this. There are a lot of different ways that the people of North Carolina could have approached this. Quite frankly, I think that the legislative procedure strikes a good balance in protecting the defendant's right, in protecting the public's right to jury trials. And I don't think it's a particularly difficult statute to follow in terms of reading the statute and following the procedure. But despite the fact that a lot of different approaches could have been taken to this in the Constitution itself or by the legislature enacting procedures pursuant to the Constitution, the people have spoken on this issue. And their word on this issue in their Constitution is the final word. If there are no further questions, let me close by, I want to go back to something. You know, this court had its 200th anniversary, 2019, I believe it was. And I know that then Chief Justice Martin on that occasion opened his public remarks commemorating the anniversary by quoting Article 1, Section 35 of the North Carolina Constitution, which reminds us that recurrence to fundamental principles is absolutely essential to preserve liberty. At the conclusion of his remarks, he reminded us once again that an independent judiciary, and this court in particular, is the ultimate safeguard of those rights. All that I'm asking the court to do today is to accept the plain language of the people of North Carolina in their Constitution and require that jury waiver cannot occur unless the constitutional requirements are strictly followed. That requires that the Court of Appeals be reversed in this case and that Mr. Hamer's conviction be vacated. Thank you, and I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice Newby. Associate Justices, may it please the court. My name is Rob Ennis, and I represent the state in this matter. The case is before the court based on the defendant's appeal of right from the dissenting opinion at the Court of Appeals. The issue before the court is whether a technical violation of our state jury waiver statute is prejudicial per se. Under this court's well-settled precedent, a statutory error requires a showing of prejudice before a defendant is entitled to relief. Defendant here failed to make such a showing. It follows that the Court of Appeals did not err by denying him relief. The Court of Appeals opinion should be affirmed for two reasons. First, because defendant has failed to show any prejudice from the procedures that happened below. And second, because the trial court cured its error and the record is sufficient to show he validly waived a jury.
Let's go back to sort of a basic point that I got out of your colleague's argument, Mr. Ennis, that I want to explore with you a little bit. If I'm understanding his argument correctly, I think he agreed with my statement a minute ago that his contention was that these statutory provisions in 279A20-1 relating to waiver for jury trials are effectively incorporated by reference into Article 1, Section 24. If he didn't agree with that, I think he's got about 5 minutes to disclaim that understanding back up. What is your response to his argument that, in essence, that the language of Section 1, Article 1, Section 24 effectively makes what the General Assembly says with respect to the procedures for waiver of the right to jury trial constitutional as compared to statutory?
Sure, Justice Ervin. My response would be that the constitutional provision that describes the statutory procedure, that the procedure be prescribed by the General Assembly, that does not, in essence, make statutory procedures constitutional provisions.
Why not? Tell me why not.
Well, Your Honor, if that were the case, then the legislature would effectively be able to amend our Constitution each time it amended procedure. And any slight deviation from statutory procedures would automatically result in a violation of constitutional rights. In other places in the Constitution, there's similar language that prescribes the General Assembly to have jurisdiction to do certain things. And my friend has not pointed to any particular authority that suggests a deviation from those sorts of statutory procedures when the authorities given to the General Assembly under the Constitution, that a deviation from those statutory procedures that it enacts amounts to a constitutional violation amounting to error per se. And so the Court of Appeals here correctly required defendant to show prejudice because the only issue before it was his claim of statutory error.
What would be, what would be an adequate showing of prejudice, Mr. Ennis, as you see it? What does that mean, assuming that your standard is the correct one?
Sure, Justice Ervin. This court has never addressed the issue, but the Court of Appeals has
sounds like we may get to now. So I want to see what you think we should do and when we deal with it, if we do.
Sure, Your Honor. Though the Court of Appeals has uniformly held that in order to be entitled to relief after your bench trial request has been granted on appeal from the judge's verdict of guilty, that a defendant has to show first that there was a statutory violation, and then second, that had the trial court not erred by granting his request for a bench trial, it's reasonably possible that he would have been acquitted had he been tried by a jury. And so the traditional standard for prejudice from a statutory violation is, absent the error, is there a reasonable possibility that a different result would have been reached out of the trial on which the appeal arises? And this court has, in cases dealing with, for instance, allegations of improper jury selection procedure, has required the defendant to show prejudice, and it seems to focus more on whether the irregular procedure impacted any of the defendant's rights regarding the rights about how he can participate in jury selection and things like that.
What, I mean, you know, I've sort of tried to think about what's an analogy to this situation. You referred to procedures for picking juries. One that occurred to me were the numerous cases that the court and the Court of Appeals have decided with respect to non-compliance with the statutory requirements for a waiver of the right to counsel, in which there is, in essence, a determination that that's error per se under state law, even though those procedures are statutory rather than constitutional in nature. They're intended to, like the procedures here, they're intended to effectuate a constitutional provision, but they are statutory in nature. Why is that not a reasonable analogy for us to take into account in this set of circumstances?
Yes, Justice Ervin, and I think that could be a reasonable analogy. In those situations, well, one difference, I guess, is that you're dealing with two very different constitutional rights. One is the Sixth Amendment right to counsel, which is very, well, of course, the right to a jury trial is extremely highly regarded as well.
Yeah, well, I was going to say, I don't think we want to start rank ordering them in terms of importance, at least between those two.
That's right, Your Honor. And yeah, the state here is not contesting that there was any sort of statutory violation. As Your Honor mentioned, the colloquy, the personal colloquy requirement is designed to effectuate a knowing and voluntary waiver. It should come first. But what happened here is that the trial court cured its error as soon as it realized its mistake, and it conducted the required colloquy. The defendant had the opportunity to reconsider his decision after seeing the state's evidence, and he still reaffirmed his decision to waive a jury.
And
There's nothing in the statute that...
I hate to monopolize the conversation, although I realize I'm doing it, and I'll stop in a second. But 158-1201-D1 describes what the colloquy ought to look like, and it says, make a personal inquiry of the defendant and determine whether the defendant fully understands and appreciates the consequences of the decision to waive the right by jury. How does an inquiry into do you understand what the penalty, if you are convicted of the offense that you're charged with, assist in that decision?
Your Honor,
Same question I asked your colleague. What is a minimally adequate colloquy for purposes of 15A-1201-D1?
yes, Your Honor. If we're comparing it, like you mentioned before, to 15A-1242, which governs the waiver of right to counsel, in that provision, there's three things that a trial court must conduct a thorough inquiry about, and that is the defendant's right to counsel, the consequences of his decision, and the maximum punishments for the offense and the nature of the proceedings against him. In this case, 15A-1201-D1 requires only that the trial court personally address the defendant and ensure he fully understands and appreciates the consequences of his decision. So it would seem to me that in order to meet the statutory requirements there, all that a defendant would have to be informed of is the consequence of his decision of waiving a jury trial is that he would be tried by a judge, with the judge hearing the evidence and it rendering a decision. And here we have information from the very beginning of the case that that defendant was aware the consequence of his jury waiver. Before the start of the proceedings, the trial court knew that the defendant was appealing his conviction from district court, that he had previously, 4 months earlier, had a bench trial where the district court heard evidence and rendered a decision. And it discussed in the defendant's presence with the defendant's counsel and the prosecutor his right to a jury trial, his ability to waive that right, his request for a bench trial instead, and that the proceeding, the consequence of him waiving that right would be that he would be tried again before a judge in a bench trial, just as he had in district court 4 months earlier. Now, the trial court, according to the statute, the trial court, of course, should have personally addressed the defendant first and not just had had confirmed with his counsel. But any error there, the trial court cured during the middle of trial by conducting the required colloquy and even directing counsel to advise him what the statute says about fully explaining and understanding the consequences of his decision. And after conferring with counsel, pausing proceedings, the defendant again reconfirmed his decision to waive a jury. There's nothing in the statute about revocation that says the defendant couldn't at that point have objected and asked to revoke his waiver or request a jury. Defendant here did not do that. The first time he's ever sought or expressed any desire for a jury was on appeal from the judge's guilty verdict. And so Justice Morgan, going to your question about prejudice, you know, I think it's a very important thing here, because if there was no showing of prejudice required, you know, any technical deviation from the statute would automatically entitle a defendant to a new trial. And defendant here has not shown any sort of prejudice from the trial court's action here. And defendant also.
If I may, I apologize for interrupting, but you've a couple of times referred to this as a technical deviation. And I just want to be clear. I have two questions, but the first one, how do we draw the line between what is a technical deviation and what would be a more substantial deviation? What's the difference there?
Your Honor, I think what makes this, to me, it seems a technical deviation is that it was one about, it was a procedural timing error. And so the court later cured that error by substantially complying with the statute by conducting the required colloquy. Now, of course, the colloquy should absolutely come first, but this is a situation where the trial court substantially complied with the purpose of the requirement, which is to ensure that the defendant knowingly and voluntarily is waiving his right to a jury.
Well, I mean, sort of technically, any deviation is a deviation from the statute, and so, and it seems to me you're asking us to, are you asking us to assume that the timing was not important? When the General Assembly said, here's the procedure that needs to be followed, and they specified when certain things should happen, that actually the timing of when those things happened didn't matter that much in the statutory scheme.
Your Honor, I think absolutely the timing of when the trial court should personally address the defendant is extremely important. As to the other notice, like the notice provision, those things, you know, I don't think deviations from those things, those aren't statutory mandates directed to the trial court. That's directed to the defendant to provide adequate notice. And so for him to complain now, if he did not provide adequate notice, that somehow invalidates his waiver, it doesn't seem to me that, it seemed to me he would be waiving that claim. And the defendant here had never raised any issue with the notice provision below at the Court of Appeals. But the timing requirements, Your Honor, absolutely the trial court should personally address the defendant first. And here, you know, the trial court technically erred by not personally addressing a defendant first. But we do have a situation where the defendant was in court when the trial court was discussing with his counsel and the prosecutor his ability to waive a jury, his request for a bench trial instead. And the trial court confirmed with defendant's counsel that defendant had waived a jury.
So the second part of my question is about whether it's the state's position that somehow, if it were not a technical violation, that it would be error per se, that there would be no need to show prejudice if it were not a technical violation.
Your Honor, under this court's precedent, when reviewing whether waivers are valid, this court conducts a whole record review and looks at the totality of the circumstances. And so in instances like State v. Rich and State v. Carter, which deal with whether a defendant's waiver of the right to counsel was valid, the questions aren't limited to, for instance, the specific questions that the judge has asked the defendant, but whether the record shows that the statutorily required information has been communicated to the defendant so that the court can make a determination whether the waiver is valid and knowing.
Well, let me ask my question in a slightly different way. Suppose that no one during this proceeding had ever mentioned the statute or the requirement that there be a colloquy or that there's any procedure that needs to be followed and had just concluded the trial. So, and just go with me that that's a substantive violation, not just a technical violation. Is it the state's position that even in that circumstance, there would need to be a showing of prejudice?
That would be up to, I guess, what this court would decide. But under this court's precedent in Bullock, if there's no personal colloquy with the defendant from a statutorily required colloquy that is enacted to guard against, unknowing waivers of fundamental rights, if there's no colloquy ever conducted with the defendant, then that has been held to be per se error. But here we do have a colloquy with the defendant. In the middle of trial, this is not a situation. Defendant cited to State v. Reyes, a Ninth Circuit case from 1979. In that case, the trial court got the defendant's consent through counsel to waive jury of 11 when one juror became ill, to waive jury of 12 and proceed with 11. The jury rendered a guilty verdict of 11. The defendant moved for a mistrial on the basis that the waiver was invalid. And then it was only at sentencing when the trial court directly addressed the defendant to make sure that he had consented to his counsel's waiver. Here, we're not dealing with a situation where there's a personal colloquy post-conviction. We have the benefit of the fact that the trial had not concluded before when the trial court conducted the required colloquy. At that point, the defendant could have, had he had any hesitation, requested a revocation of his waiver, but he reaffirmed his decision after seeing the state's case. And so here we do have a personal colloquy, and the trial court made a mistake by not personally addressing the defendant before starting the bench trial. But defendant has failed to show any prejudice from that. He's not shown that he would not have waived the jury had the trial court conducted the colloquy earlier. Defendant also has faulted the trial court for not instructing him about his ability to participate in jury selection and that he would have a jury of 12 with a unanimous verdict. The trial court here, well, for one thing, the trial court directed counsel to fully explain. The defendant here had the benefit of counsel, which is something that you don't have the benefit of. Well, I guess it just kind of makes it different than situations where you're trying to get waivers of counsel. And also there's no requirement in the statute that a trial court inquire about the defendant's knowingness of his waiver would result in the fact that he would be entitled to a jury of 12 or that he would be entitled to a unanimous verdict.
But before you pivot entirely to that point, counsel, I want to wrap up prejudice to some extent anyway. I know you talked about this being a technical violation of the statute. Your colleague on the other side talks about this being prejudicial per se, building upon the dissent's position in this case. Considering the strength of the wording of the statute, that this colloquy was to occur, quote, before, unquote, the trial begins, and that the trial judge, quote, shall, unquote, address the defendant. What would be your response concerning the state constitutional ramifications here concerning prejudice per se for failure to comply with the statute?
Your Honor, I think one flaw in the defendant's reasoning is, I guess, his use of structural per se. I mean, of structural error per se. And I'm sorry, Justice Morgan, could you repeat your question?
I'll try it. The fact that you've got such strong mandatory language in the statute, the colloquy has to occur before the trial begins. The trial judge shall address the defendant before the trial begins with this colloquy. You've got the dissent saying there are state constitutional ramifications here. You've got the defense counsel in this case building upon that by saying that this is the will of the people, that you have this change in the constitutional aspects of a waiver of a jury trial. This is also dynamically important. What's your response to it being prejudicial per se as compared to what you're saying about a technical violation, especially with the state constitution being invoked?
Your Honor, a statutory violation is not constitutional error. A statutory violation is a violation of statutory rights. Of course, failure to follow certain statutorily required guidelines can cause due process issues, for instance, with failing to secure a valid and knowing waiver. But the Constitution here, the fact that it says prescribed, the procedures prescribed by the General Assembly, does not make any General Assembly enacted procedures constitutional mandates. The failure to follow them would be prejudicial per se. If that were the case, anytime, well, for instance, before in October 1st, 2015 is when the General Assembly enacted these new governing procedures. If it were the case, before when the enactment occurred, the amendment happened December 1st, 2014. From that time until October 1st, 2015, the defendant could constitutionally waive the right to a jury trial. It's not that those procedures rendered a defendant unable to waive his right to a jury trial or able to waive his right to a jury trial. If the General Assembly amended the procedure to add certain other procedural requirements, that wouldn't necessarily impact constitutional rights, because elsewise they would have the authority to amend the Constitution just by passing new statutes.
Is a legislative mandate not prejudicial per se, even when there's mandatory language that a trial court must do something?
That's correct, Your Honor. There's several cases from this court where, although an issue is preserved on the basis that it violates a statutory mandate, the defendant still must show that he's prejudiced in order to be entitled relief. And
Counsel, help me understand the role of the defense counsel at the beginning of this trial. I guess we have this concept in our law of invited error. First off, the court says, so first of all, just technically the defendant is waiving a jury trial. Defense counsel, that's correct, Your Honor. Okay, and I presume that there's a statute that allows that. That is correct, Your Honor. We have, the state and I have, the state has consented. There is no disagreement about the bench trial. What impact, if any, should that have on our analysis?
Your Honor, I think that that just allows it shows that there's been a discussion before the trial happened, where everyone was aware of the defendant's requesting of a jury waiver, and of his desire to waive a jury and to request a bench trial. Defendant here had the benefit of counsel, and he actually wasn't entitled under the Constitution to counsel because of the charge he was facing, but he had the benefit of counsel. And, you know, with counsel's advice, and we have a record, you know, that shows that the defendant, he waived a jury, and the trial court consented to it. Yeah, and yeah, so I guess, you know, the defendant has been arguing a lot about the historical underpinnings of the constitutional right to trial by jury, and the state does not have any, you know, absolutely that is 100% it's extremely important fundamental constitutional right, in particularly in this state. But the problem with a lot of the cases that the defendant is citing is that in those situations, the defendants had unwaivable rights to trial by jury. And so they had with that an absolute constitutional guarantee to a jury of 12 and to a unanimous verdict. And so in situations where those unwaivable constitutional rights were violated, the defendant need not have objected below to preserve the issue for appeal. And the defendant, in situations where a verdict by a jury of 12 was constitutionally required, he need not show prejudice because it was error per se. Under our Constitution, we require a jury of exactly 12 persons. And so when a defendant is convicted not by a verdict deliberated on and rendered by a jury of exactly 12 persons, the verdict is a nullity. It can sustain no judgment or conviction. So the defendant need not show prejudice in those cases because there's no verdict. So he's entitled to a new trial. That's not what happened here. Defendant here waived a jury. And so with it, he wasn't entitled to a verdict rendered by a jury of 12 or a unanimous verdict. So the authority he cites for issues of issue preservation or prejudice are simply not applicable in this case. And now the Constitution now affords another mode of trial, which is trial by judge. And just to, unless the court doesn't have any other questions, I can just wrap up briefly. Just in sum, the Court of Appeals majority here did not err by requiring defendant to show that he was prejudiced from the statutory error in this case, and by not construing the statutory error as a constitutional violation. And defendant here failed to make any showing of how the irregular procedure prejudiced him. And the trial court cured its error, and the record is sufficient to show a valid waiver. Reviewing the whole record, the statutorily required information was communicated to defendant at the beginning of trial even, but in particular during the middle of trial. And he had the opportunity, if he wanted to, at that point, object or revoke or attempt to revoke his waiver, but he did not. He reconfirmed his decision to waive. And so the state of North Carolina would respectfully ask this court to affirm the Court of Appeals opinion below. Thank you.
Thank you, counsel. Rebuttal.
Counsel, do you want to unmute? Counsel, you're muted. All right, I think you're ready to go now, if you'd like to start speaking.
Okay, am I unmuted now?
Mm-hmm.
Let me respond first to the comment that you made, Justice Irvin, that you are correct in that appellant's position is that whatever statutory procedure is enacted by the General Assembly is incorporated into the Constitution. The state is arguing that that authorizes the legislature to rewrite or revise the Constitution, and that's not the case. The legislature can prescribe the procedure, whatever procedure it wants. And, you know, initially under this, in the first version of the statute, the legislature left a lot of latitude for the courts to decide what the procedure was going to be, because basically all they said is you had to personally get a knowing and voluntary waiver. It was only in 2015 that they enacted the portion giving a much more detailed procedure. I certainly recognize that this court is the final arbiter of the meaning of our Constitution. But the first principle that this court relies upon is looking to the plain language. And if that language is clear, no further interpretation is required. The language in this amendment is clear, and it is a supreme law of this state. It must be followed. To do otherwise is to change the court from an arbiter of the meaning of the Constitution into a reviser or rewriter of the Constitution. I'm concerned about the state's remark suggesting that the right to a jury trial in North Carolina, because of the exception creating waiver, is no longer an absolute right. That is not the case. The right to a jury trial for both the defendant and the public is still an absolute right, unless a constitutionally valid is made. And it doesn't wipe out this court's prior cases. One of the things that people always believe when they put their foot on a slippery slope is they believe they're going to be able to stop somewhere before grievous harm is done, or at least somewhere before they hit bottom. And all too often they're wrong about this. This court has cases going back to at least 1800 when it has said repeatedly, we're not going to put our foot on that slope with the right to jury trial in North Carolina. We're going to protect it. We're going to enforce it. It's going to remain absolute. And for those reasons, I ask you to reverse the Court of Appeals and vacate Mr. Hamer's convictions. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is in recess. God save the state and this honorable court. Thank you, counsel.